everyone ready? Because the strict separation of church and state allows for equal access to political power, I affirm and offer the following definitions. Democracy, the belief in freedom and equality between people, or a system of government based on this belief, in which power is either held by elected representatives or directly by the people themselves. Best served. This raises questions what normatively best serves democracy, is strict separation or more lax separation, or no separation at all. It poses a comparison among competing options because best is relative to other alternatives presented. For example, if there's only one person over 8 feet tall in the world, that person is the tallest person. If another person is also over 8 feet tall, there would be a comparison and the tallest would be the winner. The historical meaning of strict separation of church and state has been both confusing and contradictory. Regardless, a stable advocacy must exist prior to any further argumentation because A, each side must have an opportunity to win, and B, ground inherent to both sides, no matter how narrow, is most representative of the resolution of conflict. Originally derived by courts from the Establishment Clause of the First Amendment, separation began as an impediment to the domination of politics by a or many religions. David Felsen has defined strict separation as 1, the government may not aid religion, and 2, the government may not exclude those from a particular belief system from receiving the benefits of public welfare legislation. This must be rejected because aid could be active or passive, and we found that the benefits of faith-based initiatives can exist without causing social harms. Other authors such as Hamburger, Eakins, Corbett, and the Everson court case all dictate varying normative ideals of separation, but each maintains the government preference, violates strict separation. Still others have defined it as a kind of neutrality or the prevention of a national religion, not having religious justifications for laws or treating everything as if religion didn't exist. The U.S. Supreme Court has employed or suggested a myriad of tests including the Lemon test, the coercion test, the endorsement test, and the neutrality test. The results have been redundant, nothing is completely comprehensive, nothing works well, and nothing is clear. While all interpretations stem from the Establishment Clause, none seem adequate. Even accommodationalism has been considered strict separation. In Everson v. Board of Education 1947, the court ruled that providing busing to religious schools was constitutional because it was a general welfare program not directly in support of religion. The adoption of even one of these conditional definitions of strict separation of church and state would skew ground in the debate, and more importantly, because it is grounded in the historical nature of the resolution, misrepresent the truth claim that we are trying to prove and disprove. Therefore, I first the definition, the historically clearest definition of strict separation of church and state, which is upholding the Establishment Clause. Essentially, people should be able to practice their religion, but the government is not able to establish a religion. However, there are still disagreements over the Establishment Clause, with the exception that one religion can't be preferred over another. The uncontroversial aspect of the Establishment Clause will serve as my definition for strict separation. Arlen Adams and Charles Emmerich explain. In light of the historical record, the court correctly observed that the clearest demand of the Establishment Clause is that one religious denomination cannot be officially preferred over one another. Influenced by strict separationist dicta and early opinions, however, the court has gone further by asserting that neutrality prescribes not only government preference among religions, but also every form of non-discriminatory aid to religion in general. This expansive view of neutrality has proven controversial. While scholars appear to agree that the Establishment Clause prohibits preferential treatment for religion, they sharply disagree over whether it also prescribes non-preferential aid to religion. This provides fair ground, especially for the negative. The definition is predictable because it's historically grounded. It also decreases research burdens because it avoids all the confusing definitions mentioned above. My value is democracy because the resolution demands that both sides best serve it. Democracy requires fluidity and responsiveness to the citizens' needs in order to quickly and accurately reflect the people's will, so my criterion is equal access to political power. Equal access to political power must be the preferred criterion around for 3 reasons. First, long-term stability. The virtue of being in a democracy is not enough to constrain the greed of some leaders. As long as leaders seek more power, the citizens must also be able to critique and challenge that power and have their voices heard. Therefore, equal access to political power ensures long-term democracy. Second, equal access to political power ensures the most representative democracy because all types of citizens can run for political office. If only those with a certain worldview were allowed to run, everyone else who did not share that worldview would not be represented. Third, the normative legitimacy of a democracy is contingent upon its inclusion and equal access to policy. Iris Young, professor at the University of Chicago Law School, argues in Inclusion in Democracy. The normative legitimacy of a democratic decision depends on the degree to which those affected by it have been included in the decision-making processes and have had the opportunity to influence the outcome. Calls for inclusion arise from experiences of exclusion, from basic political rights, from opportunities to participate from the hegemonic terms of debate. Some of the most powerful and successful social movements of this century have mobilized around demands for oppressed and marginalized groups to be included as full and equal citizens in their polities. Because equal access to political power ensures the best long-term quality and normative democracy, it must be the criterion for the round. My sole contention proves that allowing the government to prefer one religion over another creates unequal access to political power. First, negating in essence creates an incestuous faux-democracy akin to theocracy. A lack of strict separation requires that one religion be preferred over another, thus giving the preferred disproportionate political weight. Besides not being able to criticize policies because they're based on A, divine revelation, and B, infallible mandates, the added weight of being federally endorsed discourages the non-favored from participating because their voices are marginalized. The attempt to participate is at best worthless because the federally endorsed face can be used as a trump card, and at worst violent because the religion uses its coercive force of the government to crush the rebellious. This creates unequal access to political power because atheists can't argue on the same plane as those in power. Additionally, opposing voices fall on deaf ears because politicians are obliged to a higher being and not their constituency. By separating the institutions, affirming doesn't favor one belief system over another. Second, any degree of favoritism towards a or many religions devastates democracy. Even religious requirements for government positions favors the outcome and worldview used by that religion. When one denomination is federally endorsed, implicitly, all other non-believers are not. Because power is relative, increasing the power of one group disenfranchises other groups not conforming to the established norm. Therefore, preferring one faith over another creates a hierarchy of political power, where ironically, the more one conforms to the established faith, the more self-determination one has. This must be a prerequisite to other impacts, because identity formation mandates conformity in order to access political power. This creates unequal access to political power by adopting the same genocidal mindset as those leading the Spanish Inquisition: convert or be oppressed. Strict separation avoids these harms by never favoring one faith over another, thus promoting equality. Because only affirming can create equal access to political power, I affirm. This is a little tricky. Yeah, no.
Sorry.
It's okay. What does the Establishment Clause say?
Do you want me to read it verbatim?
Yeah, please do.
I got it.
Is it in the AC anywhere?
No, I don't read it.
Okay, that's fine. Is the point of including, okay, isn't the point of including, what's the point of including the Felsen analysis? What does it do for you?
It just says that this definition is wrong. It's setting up that historical definitions have often been rejected.
Right.
This is a popular one.
Alright, so what you talk about is the two justifications for the establishment.
For excluding the others comes basically throughout everything up to there.
Okay.
The first argument being that
that's fine. I got that.
Felsen saying other ones have been rejected, it's historically inconstant.
Right. So how do those arguments about the historical accuracy and the research burden link to your criterion?
It just sets up the framework for the affirmative case. It doesn't link directly to the criterion, with the exception that
right, but we're making a value
preferencing is inequality.
Right, we're making a value judgment between two different definitions, right? How do we have a standard to
I don't know what you mean by a value judgment between two definitions. My argument is that we prefer my interpretation for the following reasons.
Why do we prefer an interpretation? Don't you have to yield to some sort of standard or criterion to gauge that?
Sure, it's based on historical accuracy, fair division of ground, historical interpretations.
Where did you define those criterions?
I don't define them directly. There are all constant arguments throughout the 1AC as to why I meet all of those. They're not condensed in one place.
Okay, so how do we create a hierarchy out of those, or are they all inherently equal?
You could make arguments. My argument for right now is that I meet them all.
You meet them all. Okay, so for you to win this round, for you to win your framework, then you have to meet all of those?
No, my argument is that I have to meet them better than you do.
Okay, that's fine. Is like the entirety of your case predicated on your definition?
You'd have to make arguments as to why otherwise affirming is conditional.
Okay, that's fair enough. Okay, let's look to the analysis where you talk about the Adams and Emmerich. That's it, right?
Yeah.
You seem to make a pretty big deal out of that.
I just slowed down because it gives 4 names, first and last, and then first and last, so I want to make sure when I extend. I mean, it is a good card, so I guess it's a big deal.
Okay. Alright, I'm fine, actually. Thank you very much. Can I see the Establishment Clause?
Yeah. Let me see it if I have it.
And can I see the AC, please?
Yeah.
High tech. I negate. The resolution assigns the affirmative the specific burden of upholding strict separation, meaning that church and state stringently avoid contact. This implies that anything other than strict separation results in some link between the institutions. The only means by which the state can conjoin with another institution is through legislation, since law defines why and how the state can or cannot act in a particular set of circumstances. In other words, legislation defines the very notion of the state by expanding or detracting its powers. An affiliation between church and state, then, can only exist when state legislation reflects the church's influence. Thus, because legislation is the only means to which church and state can be linked, the fundamental difference between an affirmative and a negative world is that the negative allows legislation with an explicit religious justification to be passed, while the affirmative prohibits it. The value is democracy because it is the implicit end goal of both sides of the resolution. Democracy exists to serve the people. Thus, the state ratifies policy to reflect their will and needs. Policy formulation requires a substantive process in which the government weighs between competing claims to truly discern the people's will. Professor David Paris expounds, the appropriate measure of democracy is its problem-solving capacity. In any democratic society, there will always be some perceived difficulty in values, policies, or institutions, implying the need to compare and consider alternative democratic ideals, rationally weigh evidence, and create policy from rational interaction and not mere partisan assertion. Therefore, the criterion is government engagement and substantive policy discussion. My thesis and sole contention argues that strict separation harms democracy by precluding substantive discussion about all religious-based legislation. In contrast, church-state interaction allows government to seriously consider potentially beneficial policy, maximizing the efficacy of governmental deliberation. In an affirmative world, religious law can take one of two paths. Either one, the government strikes them down directly because of their religious nature, or two, the government reformats them using secular rhetoric. Both impede government engagement in substantive discussion. Striking down laws simply because they are religious means discarding legislation that could potentially benefit society and better the democratic process. For instance, law that subsidized religious programs in public schools to educate children about various faiths could help eliminate misconceptions about religion that often lead to intolerance and social tension, but would be automatically rejected under strict separation. Meanwhile, rewriting laws with secular text precludes religious legislatures and the individuals they represent not only from discussion, but from explaining and defending themselves against the government's indicted exclusion of religion. Church-state integration assuages these harms because legislatures do not evaluate policy based merely on whether it is religious or secular. Rather, they examine the substance of the law in question and debate over the issues those laws present. Moreover, even though negating does permit the religious to pass laws, the ratification of those laws isn't guaranteed. Religious individuals still have to convince the rest of the legislative body and the populace as a whole of their policy's utility. Any policy that seeks to privilege the religious or impedes the democratic process will be naturally scrutinized by the entirety of society. At the same time, church-state interaction permits religious individuals to defend and explain religious policy that causes no such harm in the legislative process. Thus, because negating fosters integral discussion, it protects both the people's will and democracy at large. Let's go to David's case. Off of the best served definition, he tells you that he's defining his advocacy in response to some sort of alternative. There has to be a comparison between the affirmative and negative advocacy. I'd say that's fine, but he can't stick me with a specific alternative because even though best may be comparative, it's superlative, so all I have to disprove is that strict separation best serves democracy. But second, I'd say there is a direct comparison within my framework because remember, I'm giving you the explicit difference between the two worlds. In his world, religious legislation can't be passed, and in my world, it can. That's the only fundamental difference between the two, so that's fine if we look in terms of inherency. Now drop to below the Everson analysis where he talks about strict separation. I would contend that first, using the Establishment Clause is just a complete assertion in terms of just alone in terms of warrants. It has no actual persuasive warrant in it. It's just a complete assertion. Rather, you look to my analysis, which gives you a logical steps which define what strict separation is. But second, I would say it's not the definition of strict separation. The Establishment Clause is the definition of separation of church and state and not strict separation of church and state, which would make David's case non-topical. Now you look to the Adams and Emmerich analysis. First, it's not looking to the specific rhetoric of the Establishment Clause. It's saying what the court's interpretation of the Establishment Clause was, but rather you recognize that David says we gauge the round purely by the Establishment Clause, so this isn't applicable to the rest of his case. So, now go to the, and secondly, I would argue, in terms of the strict separation definition, it doesn't, like the Adams and Emmerich card says that it means that no religious denomination is favored over another, but that's not true because the Establishment Clause says specifically that there's no establishment of religion. It doesn't say anything about favoring religious faiths over one another. Now, I would say when he looks in terms of like weighing these criterions about whose definition is more important, I think this is what the round is ultimately going to come down to. Let's look to the historical, first is like a general overview. He never defines what criterion he's actually impacting back to. They're an infinite number. There's no numbering in the AC of which criterion he's linking to. So that means he's linking to his standard in the round because that's the way you adjudicate the round. If he can't show you how historical accuracy and research burdens in this round lead to equal access to political power, then you don't weigh it in the round. This isn't a justification. You look to actually warrants their arguments and debates. But second, I would say, yielding to history, he doesn't tell us why that's intrinsically valuable. Like, that means that it's happened, and I would contend that if that's true, yielding to history is valuable. I'm amalgamating, like, I'm not using one specific definition in one specific context. I'm amalgamating from, like, a myriad of research. But second, he says that in terms of research burden, it's published, and so that allows for better education because I could predict his advocacy. But I would say that he never tells you why he assumes that prediction is inherently good. I'd say that I'm challenging David to think on his feet. And I would say that that adds a new dimension to the educational process because he can prepare for something, and the goal of debate is to prepare us for the real world, and we can't always prepare for things in the real world. Blah, blah, blah. Okay, so the criterion is the equal access to political power. I'm fine with that. Every individual does have to have equal access to political power, but the government has to provide us a forum to do that and allow for that substantive discussion so that they have a tangible claim to their political power. If we move to his first contention, you can group it, because I'm not advocating a theocracy, I'm just saying that they have a tangible avenue to pass religious-based legislation, but second, that there are a myriad of checks that exist, because if people are going to try and establish a theocracy, the rest of society is going to scrutinize them. But third, I'd say, I increase participation, because I'm allowing the religious to participate and not excluding them. If you go to his second contention, I'd say group the whole thing and turn it, because remember, he's passing purely secular laws, which causes religious individuals to conform to secular ideals, meaning that he exacerbates conformity more. But remember, these really don't matter because they're more or less contingent on his framework, remember, because I'm not establishing a theocracy, and both of his arguments follow from that. So if that's true, and I'm not creating this conformity to law, then whoever wins the framework debate is more or less going to win this one.
Passing Congress goes through legislation, correct?
I'm sorry, what?
Passing Congress goes through legislation.
Passing Congress.
In order to pass a law, it has to go through Congress, right? Definitionally, when you pass a law, it goes through the institutionalized body in the legislative branch, right?
That's not like the only means like that happens, but yeah, that's one.
What are the other ones?
Well, like that policy is still checked by the judicial branch.
Okay, so the judicial branch is not engaged in the legislative process then. All it does is act as a check.
Right, sure.
Okay, so with that concession, so if the court writes an opinion using arguably completely religious rhetoric, your argument is that does not violate strict separation of church and state because that is not a policy.
Okay, the reason that I think the judicial branch falls out of the scope of this resolution is let's consider that hypothetical scenario, right? If the court has to evaluate religious-based policy and they say that it's not constitutional, that means that they're going to deny the existence of the conflict scenario. If they say this specific legislation is religious,
let's move on. I have a quick question. What's a religious argument?
What's a religious argument?
Yeah.
I would contain that all you can empirically boil religion down to is a conception of the good, a monolithic conception of the good.
So then wouldn't everything else be concessions of the good, like secularism say oppression of women is bad, is a conception of the good?
The difference is that secularism provides a multiplicity in terms of conceptions of the good.
How are there different multiplicities of conceptions for the oppression of
Well,
women?
I can be like an anarchist, I can be racist. I mean, those are other ideologies, just like religion, which provide a single, like a defining attribute in terms of...
Your argument is it's better for democracy to have those in policy.
Not to have those in policy, to provide the tangible avenue for the religious to pass that policy.
Okay, so you're maintaining the avenue for which racist policy can be passed. Inevitably, right?
Yup.
Okay. How does that serve democracy?
How does that serve democracy? Well, I tell you, one, the harm that you're talking about really extreme policy being passed is really minuscule at best because you recognize that because I'm having like a more open deliberative sphere, that it's more likely to be checked. And I'm saying that the whole point of my analysis is that we look to the substance of that law. We don't categorize it as religious or secular.
Who is looking to the substance?
The people in the legislative process. Like you define the definition of democracy as the people or the people who elected them. So that's the entire government engagement.
Okay, what does your criterion mean? Is it incompatible with mine? The government engagement in substantive policy discussion? That just means like people talk, right?
It means that they talk within a governmental forum, and the government has
So they talk
a requisite obligation to provide that forum.
Okay. Is there any arguments in the last speech as to why your criterion is better than mine?
What I said to your criterion was that it's fine, but the government has to provide like a tangible form to provide that equal access to political power.
Okay.
So I'm kind of combining the two.
Okay, but there's no arguments as to why your criterion is better than mine in the last speech.
That's right. I'm trying to combine them.
Okay. Go ahead and correct. We're going to be starting at the very top of the 1AC on the transfer analysis. going all the way down the affirmative case. The only parts that'll be cross-applied to the negative case will be on his framework and on his criterion, and then address the negative case. He says that I can't pin him into a specific alternative, but look to the two prerequisites I give you before you evaluate anything else on the framework analysis. The first is that I have to have the chance to win. This means I should have the ability, because preemptively in the one I see I have to be comparative, definitionally in the resolution. This means that if he's just picking on an alternative that I didn't advocate in the last round, then he's skewed time for 6 minutes. But the second argument is also conceded, saying that I can use a very narrow interpretation to justify the only things that are inherent in the resolution. These are two arguments that are conceded that I say you have to evaluate before any other standards debate on the framework analysis in the round. So that's the lens through which you view framework. He gives two arguments against the Tellson evidence. The first is that it's not a logical step of strict separation. However, first, it's better because it's based on the historical evolution of the term. My interpretation cites court cases since the interpretation arose in 1947 and how it's changed by citing authors such as Corbett and Hamburger. This takes out his second argument, saying that I'm not specific to strict separation because both Corbett and Hamburger are, and they still have no clue what it means. Therefore, the alternative is we look to what's inherent. He never makes any argument saying that the only thing we know for sure about strict separation is that it doesn't prefer religions. So this takes out his definition of strict separation for a couple reasons. The first is that he concedes the argument below the argument about predictability, saying that the resolution has to be grounded in the historical nature of the resolution because strict separation is a historical term. Because this isn't empirically how it's been applied, but empirically mine is how it's been applied because it's the only thing that inherents, mine ought to be preferred. The second argument is that his would say that courts are never part of the process. This is intuitively untrue because they've been the ones who've been giving the court decisions, such as Everson v. Board of Education. So now he's really losing on the framework debate. He gives a couple more arguments against Adam and Emmerich. The first argument is that that Adams and Emmerich are only giving their interpretations of what the Establishment Clause say. But not only are they giving their interpretations, they're giving the interpretations of every single other scholar who's ever evaluated the Establishment Clause, meaning that the only degree of consensus there is in the political level and on the scholarly level is that strict separation of church and state and establishment means you don't prefer one religion over another. His second argument is that he's not advocating an establishment of religion, and that's not what my interpretations say. But first, I would argue that Adamson and Emmerich know a lot more about the Constitution than Matt Shields does after his history classes. But secondly, I'd argue he never justifies his assertion against my argument. Now on his overview, he gives three arguments. The first is that I'm not justifying why it ought to become before everything else. I told you that it was a prerequisite to evaluating it because the framework has to be something in which I can have a chance to win the debate. I prove why his interpretation makes it impossible for me to win the debate because it functions as a time skew, and we never know exactly how it's played out because we don't know exactly what is inherent to strict separation, except for that you don't prefer one religion over another. His second argument is that predictability is bad. However, I'm predictable only in the sense that it was going to be historically grounded, but he had no clue how I was going to tweak it, so that just becomes a wash. Against my criterion, he said I need a forum for people to participate. However, the forum is the public sphere. By creating equal access to political power, you have a prerequisite to this government engagement criterion of basically just people talking, because it makes sure that the voices are heard at an equal level. Remember, his criterion doesn't specify equality, whereas mine does, which he says is part of democracy. So then go to the affirmative case proper. His first argument is that he's not advocating a theocracy. However, the first contention establishes that any degree of preferencing is going to lead to a theocracy because the laws are going to be based on A, divine revelation, and B, infallible mandates. But if anything, C, they're going to be unable to be criticized because they're based on the federal weight of endorsement, meaning that at best their voices are going to be washed, and at worst they're going to be acted violently against. This takes out a second argument saying there's no checks because they're overwhelmed. His third argument is that he allows religious people to participate. However, turn it against him. I let people participate, especially the religious, by saying that they're equal on a secular level. What I don't do is let secularism or religion take preference over one another, meaning that I better protect them in the long run. His only argument against the second point is that the only secular laws leads to conformity. However, turn it against him with the identity formation argument at the bottom, saying that the only way we can conceptualize things is by making sure we don't have an incentive to convert ourselves to an established norm, meaning that he justifies things like genocide, which outweighs his case, because he's saying we have to conform in order to gain power. Against his negative case, there are other alternatives. First, you can say you can have both religious and secular justifications for policies. This means that there's a C point that he didn't predict. And secondly, argue that you just don't write justifications for laws at all. There's no reason why policies by the government have to have reasons for them in them.
Matt, you have 136 left.
Thank you very much. We're going to start, before I begin, I'm sorry. We're going to start at the top of the affirmative case. Then we'll be going for the framework, then to the negative framework, and I'll be crystallizing as I go along, if that's all right. Everyone ready? Looking to the best served analysis, his first response is that he has no chance to win, and that, like his definition, I have to provide an alternative. I tell you specifically that I'm providing an alternative, but one, on a definitional level, an alternative that accounts for every single alternative that I could possibly advocate. I'm providing for the fundamental difference between the two worlds. He says that he can provide an our interpretation. That's fine as long as he adheres to my interpretation, because I'm going to show you why he loses. Now go to the Everson analysis. He tells you that it's historical, and he gives he says it's historical in terms of the research burden, so I'll get to that in a second, but extend the analysis that he concedes that it's still an assertion. That's going to become really important in the debate. The next response is that Corbett and Hamburger don't know, he says that Corbett and Hamburger don't know in terms of defining what separation of church and state is. What I'm telling you is the rhetoric in the AC is we look to the Establishment Clause to decide what strict separation is. The problem is that the Establishment Clause isn't looking to strict separation, it's just looking to separation of church and state. Dave can't define his ground in terms of something that's looking to just separation of church and state. The impact that I gave you is this is conditional, so David isn't meeting his burden as the affirmative debater to prove the resolution true, meaning this is the first reason that you negate the resolution, and that means that David loses on face because his case isn't topical, it's not applicable, it doesn't achieve his burden. So, now go to the Adams and Emmerich analysis. It becomes a little muddled, but I'm not going to let that happen. Let's look to the first bit of analysis. He says that strict separation has been defined by a plethora of scholars. The problem is, the problem with all the arguments that he makes is that he's still impacting to an external criterion. Why the hell do I care what a bunch of scholars think? Remember that what's more important, and now you can jump to the bottom of the analysis under the criterion, is I tell you, because he's not specifically defining his criterions of predictability and history, and this is really important, that means he's either A, linking to his standard, or B, we default to whose argument is more persuasive in terms of logic. So he doesn't meet either of those burdens, because one, he doesn't link anything in terms of predictability and historical accuracy, he doesn't link any of that to his standard, and two, in terms of using logical warrants, he concedes that his definition of strict separation is purely an assertion. So that becomes my second voting issue. It has a few prongs to it that you keep in mind. It's the definitional debate. Here's why I'm winning it. One, he never defines his criterion, his external criterion, such as looking to historical accuracy, and two, predictability. He doesn't give us any definitions of them, doesn't define them as standards in the AC. That puts him in a double bind. Either one, he links to his standard, or two, he looks to who argues more persuasively. And remember, I'm winning both those criteria because he doesn't link any of his predictability and historical stuff to his criterion, and two, my argument's just a lot better, and we'll get to that. But then go to the Adams and Emmerich analysis again. I'm still winning this. What he says is that Emmerich and Adams know more than me. I don't know how Wolfish knows that. I guess he's really good friends with Adam and Emmerich and me, but we don't have play dates. So the second response is that it's a pure assertion. No. What I'm telling you is that Adams and Emmerich are wrong. They say that the interpretation is that the Establishment Clause prefers one religion over another, that that's not the rhetoric in the Establishment Clause. It says we don't establish a religion. It doesn't tell you why that's exclusive of another religion. I think it's a really logical link, but there's no reason why you can make that when David tells you the only way we gauge what strict separation is through the Establishment Clause. So that becomes my next voting issue, that you throw the Adams and Emmerich analysis out of the round. Now, go to the historical and education analysis where I actually show you how I'm meeting those and turning them. So even if you're buying his interpretation, his external performative criteria, you look to one, that I'm actually better for history because I tell you I'm amalgamating a myriad of research and a myriad of applications of how strict separation has worked, so you can turn that analysis. But second, he says his is historically grounded, but doesn't compare that because I'm impacting in my second response to the fundamental goal of debate, which although I made a joke out of it, it's still applicable because the ink was there, that the goal of debate is to prepare us for the real world, and the fact is in the real world you aren't always prepared for your opponent's responses, so I actually have a real world impact. That's something that David can never outweigh, so when we weigh our two advocacies, that's another pre-standard reason to vote for me because my next voting issue. His standard's fine. Now let's go to my framework. First he talks about predictability, it's empirically applied, but I've already dealt with that analysis. Then he says that there can be court decisions as opposed to the legislatures, but remember I tell you in CX that denies the conflict scenario, because if the court rejects religious legislation in my society, that means I'm intrinsically affirming the resolution, so we take that power out of their hands, it's extra topical. That in mind, he doesn't deny my analysis. One, you remember, the state is defined in terms of legislation because it expands or detracts its powers. So that's the only means by which the state can conjoin with another institution. That's called a warrant. That's not just a yielding to authority or yielding to external criteria. That's called logic. I show you something, and then I show you how that leads in terms of a causal relationship to a conclusion. So that means the fundamental difference between the two worlds is that the negative allows legislation with an explicit religious justification to be passed, while the affirmative prohibits it. He never shows you how he links to my advocacy, and that's the way you're gauging the round, because we're looking to debate as opposed to, we're looking to debating and warranting the issues as opposed to assertions. His next two responses is that they can use religious and secular justifications for laws. No, because in my society, that's the only time you can pass religious legislation. That's exactly what I'm telling you. His second response is that no laws have reasons attached to them. But remember, that's not true. Like, the only laws that don't have reasons attached to them specifically are secular ones. That's fine. Religious ones do have reasons attached to them. That's the only way the two institutions could possibly be integrated. That in mind, you extend the case. There are two implications. One, striking down legislation means discarding legislation that could potentially benefit society. I'd say that allows for more equal access to political power because you're having better laws. You're not essentializing them and putting them in terms of religion or secularism. You're looking to the substance of those laws. That's a direct impact back to equal access. And two, individuals that the religious legislatures and individuals they represent are precluded from discussion and explaining and defending themselves, so they don't have equal access to political power, and that's my last point.
I'm going to be giving a quick overview about the NR strategy that you can flow wherever you can find it when making your decision. And then we're going to go straight down the app, and then I'll deal with the neg inclusive within the app for the most part. The point of the 1EC framework and 1AR framework is to justify affirmative conditionality, but insofar as Matt never extends any arguments into the last speech or makes any voting issues about why I'm conditional, that I don't really need to win the framework anymore, but I'm going to anyway. His first argument is at the very top, saying that he has to provide an alternative that is encompassing within all other alternatives. I say this is fine, but then I get to pick because I have to be preemptively comparative in the 1AC, or otherwise face a 6-minute time skew, then I should be able to get the one to specify. I specify theocracy. His first voting issue is that if you look to the Establishment Clause, all my analysis is talking about separation, but not strict separation. Remember, he never draws a delineation between the two, but even more importantly, you can cross-apply the argument that I extended at the very beginning of the 1AR, saying the prerequisite to any evaluation of any definitions in the round, in the framework for the framework debate, in the lens through which you view framework, is that I must have a chance to win. My argument is that I have no interpretation and no way to win against his definition because it has no historical precedent. Comparatively, we know historically, which is the criterion through which to view this framework of the framework, that my criterion, the only thing inherent to strict separation is that you can't be preferring one religion over another. This justifies my interpretation. His second voting issue is that I'm not meeting his burden, and he says that predictability is bad. However, I told you in the last speech that this is impossible for me to meet because he never says how predictable I have to be, but I also made the argument that the historicism is always going to outweigh it because I traced the lineage of strict separation from its origins back to what it is now. This means my definition is comparatively better than his because it gets a better representation of what it's meant over the years and what's inherent to it. This also links back to my first voting issue, which is that I have to be able to win the round in the framework debate. This is the argument that's the prerequisite to everything else that's explicit in the 1AC and the 1AR. It's at the top of the framework analysis. The argument says that if I prove that his argument doesn't give me a chance to win the round, then you reject all of the negative arguments. He doesn't give me a chance to win because A, his definition isn't based off of historical interpretation that we can track, and because of the B argument in the prerequisites, justifying that we can only look to what's inherent to strict separation of church and state, and that is just that you don't prefer one religion over another. Then he makes a voting issue about the real-world implications. He says this is a priori. That's fine. Extend the link turn I gave in the last speech, saying that it's predictable in the sense that it's based in the literature, but it's not predictable in the sense insofar as no one else in the debate tournament is giving the same interpretation as I am. Now use his a priori standard against him, and I'm outweighing him on the a priori level that he sets up in the last speech. So if you're looking to this a priori issue, I'm outweighing him. So now I'm winning tons of offense because my definition is better educationally because it's based off of historicism, and the Adams and Emmerich evidence clearly established the only thing that there's no conflict over empirically is that you don't prefer one religion over another. Now extend the second point, saying that he justifies genocide with preference by saying that one religious faith is valued over another. Also extend the argument saying that I'm operating on the identity formation level because he's creating an incentive at all for people to conform to norms. That means they have nothing new to bring to the political process and to the legislative level. I told you in the last speech that this preempted the negative case because if people are trying to justify laws, they can only do it in one mindset. I also told you in the last speech that the genocide outweighs his arguments on a magnitude level because millions of people die. It has a clear impact back to equal access because they're dead.
two. So what happens is, to squash one